Okay, all right. Sri M.S. Natchiappan.
Support the bill Black Money, Undisclosed Foreign Income and Assets and the Imposition of the Tax Bill 2015. As our leader has said, Congress party fully support this bill, but at the same time we have to bring certain deficiencies which are there to be rectified in future amendments. First of all, I would like to draw the attention of the government that we are bound by the United Nations General Assembly, which has made as early as 31st October 2003, that on the basis of the recalling its resolution 55/61 of 4th December 2000, it has established the ad hoc committee to go into the issue of this type of evasion of the taxation throughout the world. It had happened for 3 years by having different types of meetings, and finally they came forward with the United Nations Convention Against Corruption. I just quote the beginning of that preamble. I quote, concerned about the seriousness of the problems and the threats posed by the corruption to the stability and security of societies, undermining the institutions and values of the democracy, ethical values and justice, jeopardizing the sustainable development and the rule of law. This is where the government was having all the state parties of the convention who have signed. 140 countries have signed this convention. On that basis, different levels of discussions were going on. And finally, they came out with this, with different topics, with the different chapters, so to say, covering about 71 articles and different ways every state parties have to follow in their own country. I find that this particular amendment, this bill, which is coined as the Black Money, Undisclosed Foreign Income and Assets and Imposition of Tax Bill, is very, very fragile, and it is only the extension of the Income Tax Act 139. The 139 section is very clear in telling that the compulsory filing of the income tax return, in various cases they are telling it. Finally, subclass 3(1), any asset including financial interest in any entity located outside India, or 2, signing authority in any account located outside India is required to file a return of income in prescribed form compulsorily, whether or not he has income chargeable to tax. But if we see the present act, which defines why this particular act has come into force, on the basis of the definition, we can find class 2(11), undisclosed asset located outside India, means an asset including financial interest in any entity located outside India held by the assessees in his name or in respect of which he is beneficial owner, and he has no explanation about the sources of investment in such asset, or the explanation given by him is, in the opinion of the assessing officer, unsatisfactory. This is more or less expansion of section 139. If we go further, the class 4 also defines like that. And finally, we can very easily find out how the architecture of this bill is repeated on the basis of the Income Tax Act. Income Tax Act is also having the assessing officer. It is having its own higher level of hierarchy of the officers to go into it. And finally, if the officer has given a verdict, then about that, there is an appeal provision is given for the tax appellate tribunal. Similarly, the same tax appellate tribunal is vested with the same powers for this act also, for this violation also. And then they can go to the High Court, and finally they can end up in the Supreme Court. This is the architecture on which this bill is made. That means we are repeating the same act which is already in existence in Income Tax Act, and we are culling out certain portion and defining it further and saying that we want to stop the black money. It is actually we are more or less we are not addressing properly which we promised to the public. To the public and also the international conventions, we have shown that we will be making such a position. I will read that portion of the Article 3 of the International Convention, scope of application. The convention shall apply in accordance with its terms to the prevention, investigations and prosecution of corruption and to the freezing, seizure, confiscation and return of the proceeds of the offences established in accordance with this convention. This is the promise we have made it. This is the convention, we have accepted it. But now we have not mentioned anything on the topic of prevention, investigation, only the prosecution is there, and the seizure, there is nothing on the freezing, seizure, confiscation and return of the proceeds of the offences. That means we want to just make a whitewashing of our own enactments, telling that we are very much interested in black money abolition, therefore we are bringing a law. But really we are not making the law. We are just evading our international commitment which we made it. Similarly, if you go to the chapter 2, preventive measures, Article 5 clearly says what are the preventive measures you have to make it in an enactment when you are making the state represented by the state. There they can make it very clearly in the Article 1, statement of the purposes. The purpose of the convention are to promote and strengthen the measures to prevent and combat the corruption more effectively, efficiently and effectively. B, to promote, facilitate and support international cooperation and technical assistance in the prevention of the fight against corruption, including in asset recovery. To C, to promote integrity, accountability and proper management of the public affairs and the public property. That means we are very clearly, we have to come forward with a domestic legislation covering the preventive measures, that is the preventive anti-corruption policies and practices, which says in the Article 5.1, each state party shall, in accordance with the fundamental principles of its legal system, develop and implement or maintain effective, coordinated anti-corruption policies that promote the participation of society and reflect the principles of the rule of law, proper management of the public affairs and public property, integrity, transparency and accountability. We are not covering all these things, but we are making very small definition here. Article 7, public sector, how the public sector has to be accountable for this purpose. Article 8, codes of the conduct of the public officials. Lot of explanations were given. Article 9, public procurement and management of public finances. These are all resources of the black money. These are the sources on which it will be coming out. Article 10, public reporting. There is nothing in it. It takes, taking into, I'm reading that portion, taking into account the need to combat the corruption. Each state party shall, in accordance with the fundamental principles of the domestic law, take such measures as may be necessary to enhance the transparency in its public administration, including with regard to its organization, functioning and decision-making process. Where appropriate, such measures may include inter alia. In that way it goes on explaining it. Article 11, measures relating to judiciary and prosecution services. This only we have made it in this act. Nothing more than that, but it is already intact in the Income Tax Act. Article 12, private sector. Each state party shall take measures in accordance with the fundamental principles of its domestic law to prevent the corruption involving the private sector, enhance accounting and auditing standards in the private sector, and where appropriate provide effective, proportionate and dissuasive civil, administrative or criminal penalties for failure to comply with such measures. Nothing is addressed on this aspect here. And Article 13, participation of the society. Nothing is addressed here. In the same way, Article 14, measures to prevent the money laundering. Already there is an act which is also fragile. Chapter 3, Criminalization and Law Enforcement. Article 15, Bribery of the national public officials. Nothing is addressed here. Article 16, Bribery of foreign public officials and officials of the public international organizations. Nothing is addressed here. Article 17, Embezzlement, misappropriation or other diversion of the property by a public official. Nothing is taken into consideration. Articles 18, Trading in influence. Article 19, Abuse of functions. Article 20, Illicit enrichment. Article 21, Bribery in the private sector. Article 22, Embezzlement of the property in the private sector. Article 23, Laundering of the proceeds of the crime. Nothing is addressed here. Article 24, Concealment. And Article 25, Obstruction of justice. Article 26, Liability of the legal persons. And Article 17, Participation and attempt. Article 28, Knowledge, intent and purpose as elements of an offence. Article 29, Statute limitations. Article 30, Prosecution, adjudication and sanctions. Nothing is addressed here. Article 31, this is very, very important. It is totally missing. It is against the wish of the people. Article 31, Freezing, seizure and confiscation. I will read that portion alone. Each state party shall take to the greatest extent possible within its domestic legal system such measures as may be necessary to enable the confiscation, A, proceeds of the crime derived from the offences established in accordance with this convention or property, the value of which corresponds to that of such proceeds. B, property, equipment or other instrumentalities used in or destined for use in offences established in accordance with this convention. Nothing is addressed in this act. Easily we can say Money Laundering Act will apply to it, but it is not applicable. It is more or less diluted. It is not a criminal basis. Criminal justice is not given in that. It becomes a somewhat diluted way. Article 32, Protection of the witnesses, experts and victims. Nothing is said here. Article 33, Protection of the reporting persons. Article 34, Consequences of acts of corruption. Nothing is said here. Article 35, Compensation for damages. Nothing is said here. Article 36, Specialized authorities. Only our own officers are becoming the persons to arbitrators of income tax. If they are violating that particular provision, then they will be deciding it. Article 37, Cooperation with law enforcement activities. Article 38, Cooperation with the national authorities. Cooperation between the national authorities and the private sector. Article 39, Bank secrecy. Article 40, Criminal record. Article 41, Article 42, Jurisdiction. And finally, international cooperation. Nothing is said except one chapter which says that this is a way we will be going for bilateral relationship, but we are not following the international convention where we have signatories to that. Article 43, international cooperation. Article 44, extradition. We are not applying the extradition at all. Article 45, transfer of sentenced persons. Article 46, mutual legal assistance. Article, in that way it goes on till the Article 71, but none of these things, criminal, transfer of the criminal proceedings, law enforcement cooperation, joint investigation, special investigative techniques, and finally, asset recovery. Article 51 says, Article 52 says, prevention, detection of the transfers of the proceeds of the crime. Nothing is said here. Measures for the direct recovery of the property. Article 53. The 54, mechanism for recovery of the property through international cooperation and in confiscation. International cooperation for purpose of the confiscation. Article 55. Article 56, special cooperation, return and disposal of assets. Finally, technical assistance and information exchange, and it goes on like that till the 41, mechanism for implementation, chapter 6, 7, article 67, conference of the state parties in convention. Now we are going to attend the conference of state parties. 2015 is going to be started. What we are going to report it? Are we going to give this small, fragile bill before the international body to tell that we are preventing everything, but we are the signatories to the international convention? Sir, I request the government should come forward with a new amended bill, more so a comprehensive act to address all the provisions of the convention were the signatories as early as 2003, where the NDA government was there. And subsequently, you are given another chance. But instead of talking something outside and doing something inside, we can straight away go forward with a proper convention, with a proper domestic law. That will be a good thing to show that India is an investment destination. You can believe us. Come here. We are following the international convention. Thank you very much.